Thank you very much. And I can introduce Mark Clough for his speech. Mark is one of the UK leading experts in EU and competition law. Thank you very much.
Thank you, Diego. Ladies and gentlemen, it is a great honor for me to address you today, and I must thank Francesco Lauro for daring to invite me back to this conference. I think it must be 3 years ago that I was last here. And as I have recently moved back to be based and to work in Brussels, I'm very pleased to be associated with the Studio Legale Lauro here in Naples as well. And I'm looking forward to collaborating with Francesco. But I'm supposed to be frightening you, I suppose now it's before lunch, about competition law. And I apologize because you haven't come here ready to hear about competition law. But let me just address two questions. The first one is, why is competition law important? And you'll understand from what we've heard already about the shipping finance sector that a competitive shipping finance sector would be, of course, a major advantage to the shipping industry. Equally, the shipping finance sector may need to keep an eye on what happens in the shipping industry. Why? Well, there are increasingly what we call personal penalties for infringement of competition law. If you take the United Kingdom as an example, you can be sent to prison for 5 years if you're found to have participated in a cartel, fixing prices, sharing markets. You can also, if you're a director of a company, be disqualified for up to 15 years. That's made a big difference in the United Kingdom, and there are other member states in Europe, not to mention the United States, that you will know about. But in addition, and on top of that, you will all remember that a company may be fined up to 10% of its global, worldwide annual turnover. Microsoft was fined over €1 billion by the European Commission, which likes to try and get above the 1 billion threshold as often as it can today. You may think that's crazy in the economic climate we live in, but it's still what the regulators are doing. On a more practical level, to quote Francesco earlier this morning, what we're doing here, your contracts will be void and unenforceable. You will have reputational damage with your customers or your suppliers. And just the time and cost of paying people like me to deal with the problem is actually a major burden for companies. And to cap that, in a few weeks, there will be published a directive which will enhance and improve the circumstances in which one business can sue another or consumers can sue a business for damages for competition law infringement. So I think that may answer the question, why is competition law important? Second question, what are the main areas of risk? And I'll just be brief here to give you a taster. The main area I think that we in this room need to be concerned about are meeting and working with competitors. You may suddenly look around and say to yourself, my God, did I bring my protocol for attending conferences with me? Have I been to a trade association meeting recently, and was there a lawyer in the room to make sure I didn't talk about prices with my competitor? Or does a bank invite all its shipping clients to a meeting and start talking about the market and the different rates they charge out in front of them? All these things have been considered by competition authorities, and I'm afraid if they catch them, they will deal with them in the ways I've outlined. Let me give you another example of dealing or working with competitors. I'm sorry, it's another United Kingdom example. Barclays Bank and the Royal Bank of Scotland. Some guys, young guys, moved from the Royal Bank to Barclays Bank, as is often happens in the banking sector. And they got together with their old friends, Barclays and RBS, went out for a drink in the evening. And they happened to be working on a consortium loan, the two banks, to one of their big customers. And so they started talking about the interest rates they were going to charge independently in theory. What happened? The next morning, one of the Barclays employees told their head of competition compliance, who picked up the phone and blew the whistle to our Office of Fair Trading, now called the Competition and Markets Authority. What happened? RBS was fined £30 million. Barclays got off scot-free because they got immunity from fine for blowing the whistle. Now that is a very interesting story, one we could pursue maybe over lunch. Why is that situation, which must happen so often, a consortium loan arrangement? Why is it that the banks should independently charge their own interest rate? The competition authorities say they should. The same thing with the LIBOR, information exchange between competitors. As you know, the way the LIBOR overnight interest rate has been determined by the input from the various banks, in particular those that belong to the national banking associations, has been said to distort the interest rates. That, again, is considered a serious infringement of competition law. So, we've heard talk about the private equity putting capital in. The same issues arise with the private equity. If you have venture capitalists who start agreeing not to compete for a particular auction, or not to offer money to a particular investment, or to agree how they go about it, that is also totally contrary to competition law. And then just looking quickly on the other side, due diligence, I'm going to call it. In other words, the banks, the lenders, they've got to carry out due diligence on those they're lending money to. And no one borrowing money is going to say they belong to a price-fixing cartel. So the bank's got to watch what it does. And what we say on the legal side is when a company, and I would say by analogy a bank, acquires a new business, don't just stop on day one the due diligence, because you then have to look to see what you've inherited. You need to do some internal searches. And I think in a big loan situation, a bank would want to do the same. And what sort of things have we seen in the shipping industry in the last few years? Well, there were dawn raids, you may remember, excuse me, 3 or 4 years ago, about alleged price signaling by ship owners. We then have the famous debate about the P3 and now the P2, the vessel sharing agreements between Maersk, MSC, and originally CGM, CMA, which was banned by the Chinese Competition Authority. Okay? It's not just Europe and the US, the Chinese Competition Authority. And so now we have the P2, which leaves out the French companies. And there's all the discussion about consortia agreements generally if they'd fall outside the safe harbor of the block exemption regulation, because they're subject to what we call self-assessment. You have to ask a lawyer to help you if your market share is more than 30%. A lot of discussion in Italy about state aid. I won't go into any detail because I've run over my time already. But state aid is another area for due diligence, because if you're a recipient of state aid and a bank lends you money, it may want to know whether that aid is lawful or not, because you might have to repay it if it's unlawful. So finally, what do we do about it? Well, just two things. A lot of companies today, and I even include small and medium-sized businesses, have a competition compliance policy. It's part of this whole world that we are hearing about from Manuele Grimaldi and John Laris this morning, the corporate governance regulatory scene that you are all caught up in, and there seems to be no escape from it, but competition law is now included in most companies in that list of compliance. And if you want some free, a lawyer telling you something free, advice on how to do competition compliance, I am part of a working party of the International Chamber of Commerce's competition committee, and we produced a toolkit which the European Commission DG Competition has kindly put on their website, so you can look at it. And it even has a one-page summary for small and medium-sized businesses. Thank you very much.
Mark, thank you very much for your interesting speech. I think you introduced a very interesting point and different perspective in our agenda.